what kinds of things might happen in IP litigation? Like, what are things you might plan for?
Okay, we're going to focus today primarily on patent litigation because that was the subject of this discussion. And there's a lot of things that happen in patent litigation. I kind of think of it as divided into 5 different phases. And the first phase is the kind of the pre-suit phase. And depending whether you're offensive or defensive, this is the time before the complaint is filed. This is the time when, if you're being offensive, you're pulling together all of your best evidence, you're deciding what the value of this case would be, and you're looking at how much it's going to cost, you're choosing the appropriate counsel, and you're choosing where you want to have this litigation go forward. If you're being defensive, you've probably received a cease and desist letter, and you have to do similar things. You're collecting all of your evidence that may be relevant. You're identifying all of your witnesses. For both sides, it's really important that you put in place a document preservation plan so that no key evidence is lost or inadvertently deleted. This is also, when you're defensive, it's where you're going to choose your counsel and decide how you're going to go forward. Patent litigation can take 3 to 5 years on an average. So it's a long process, and it can be quite expensive. So some thinking about how you're going to go forward is really important. And in the pre-suit phase, you'll probably discuss the possibility of settlement. You'll look at your exposure, and you'll think about how you want to respond to the cease and desist letter to the other side. There's a lot of different choices available at that time, and you'll go through all of them with your counsel, hopefully. Then there's the next phase, which is from the filing of the complaint to the case management conference. That's the phase where a complaint is filed. The plaintiff has explained exactly which patents are asserted and which products are accused of infringement, and plaintiff really has to make clear what their infringement theory is. And then the judge will meet and set and eventually have a conference where the judge will ask what the case is about and say, okay, let's give you a schedule, and how long do you need for discovery? It's going to take you 6 months or a year to collect all the information you need, take depositions of each other, and ask each other questions, get your documents. And parties usually try and agree on that. Maybe there's some initial disagreements, and then after the case management conference, you go into the third phase of discovery, which is from the beginning of discovery, from the case management conference through the Markman hearing. And the Markman hearing is unique to patent litigation. It is a special hearing that happens where the judge decides, after a hearing, that's almost a full trial, what the claims of the patent mean. And it seems like it would be obvious the claims mean what they say, but it's actually really complicated. And there's a lot of litigation about what does the actual words of the claim mean, how far do they cover, how broad are they, how narrow they are. And there's a lot of strategic decisions to decide about this. If you're a plaintiff, you think often about making your claims broad enough to cover the accused product, but narrow enough to stay away from the potentially invalidating prior art. And then after that, there would be another phase, which is through the claim construction ruling to expert discovery. And expert discovery is when each party will exchange expert witnesses and talk about what their damages theories are and why the patent is invalid. And that's a big phase of the litigation where you really kind of solidify the points that each party is going to make. And the last phase of patent litigation is the pre-trial and then the trial, which is obviously the most significant part of the case, and where a lot of it is determined whether the case will settle or whether there'll be an adverse ruling against one party, whether there'll be an injunction entered, whether there'll be damages awarded. So those are the phases of patent litigation at the district court. Of course, when there's a lot of money at stake, there's probably going to be an appeal by one side or the other. And appeals from for patent issues go to the Court of Appeals for the Federal Circuit. No matter which court you're sued in or which court you have your trial in, they all go to the special court for patent appeals, which is an interesting situation because some courts have a lot of experience with patent litigation and they do a really good job understanding the laws. And sometimes if you're involved in a litigation in a district where a judge does not have a lot of experience with patent litigation, it can be very challenging for the judge to grasp all of the nuances of patent law for the first time when parties are being very adversarial in front of it, in front of him or her, and then have that decision looked at by a panel of experts in patent law. So those are the phases of patent litigation. I know that you only asked me about the phases, but I want to talk about cost and settlement a little bit with regard to each of the phases, and I have made some notes. I think that there's a lot of patent litigations filed, sure. But once a patent litigation is filed, about 50% of the cases settle just before the case management conference. That's in the first 5 months of patent litigation. So that's important to keep in mind. And the reason a lot of cases settle is because some of them it's just not worth fighting. Some of them the demands are very low. Some of them they were baseless in the beginning and the plaintiff withdraws them. There's a lot of reasons that cases can be dismissed in the first 5 months. And if you're a defendant, that may be good news to you, and you can get out of your case quickly, and that's great, and get back to competing in the marketplace. In the first 5 months, I talked about having in the big cases, maybe 5 to 6 million total costs and expenses in litigation. And in the first 5 months, in that first phase of litigation, you can think about maybe 5 to 10% of costs and fees would be incurred in that first phase. And then from the scheduling conference, when the case officially really kicks off to the Markman hearing, the good news is about 90% of cases settle in that phase. So even if you're a defendant, you can have in the back of your mind when you're doing your cost modeling that's about when most cases settle. And still in that phase, you're only looking at about spending 15 to 20% of your total costs and fees on average of across all patent litigations. Then from the claim construction through the end of expert discovery, 97% of cases are settled by the time you get to this phase, which is a huge amount. Here you're starting to spend money. This is 30 to 40% of your costs and expenses are already spent by the end of this phase. So it gets really expensive, and I think that is obviously why a larger portion of cases settle at this point. And then pre-trial and trial, it's a very small amount of cases that get this far. Maybe 3 to 5% of cases go that far, but you're looking at 40 to 50% of your costs and fees in this last phase. So it's really expensive to go there. And in my experience, there's a lot of reasons why some cases make it that far. And maybe it's because the plaintiff and the defendant see the value of the case so differently, maybe because there's been a lot of close calls on the rulings, or maybe there's just real personal animosity between the corporations. There's reasons these cases go that far, but that's really where it gets expensive.